Protected lease renewals under the Landlord and Tenant Act 1954 are crucial for commercial tenants in England and Wales. They ensure that tenants can remain in their premises even after their lease expires, unless formally excluded. In this video, we'll explore how these renewals are initiated, how landlords can oppose them, and the importance of timing and procedure for both parties. Security of tenure means tenants can stay in their premises after their lease ends, unless the lease was excluded from the Act. This provides stability for tenants while allowing landlords specific grounds to regain possession if necessary. Renewals can start in two ways. A landlord can serve a Section 25 notice, or a tenant can serve a Section 26 request. Both require 6 to 12 months' notice, and once a notice is served, the landlord's position cannot change. Timing and service are critical. Notices served too early or late are invalid, and missing deadlines can give the advantage to the other party. For instance, if a landlord fails to respond to a Section 26 request, the tenant secures renewal rights automatically. Landlords can oppose renewals on specific grounds, such as tenant faults or management intentions. These grounds must be backed by solid evidence. Mere intentions are not enough to succeed in court. If a tenant contests an opposed renewal, the court will closely examine the landlord's evidence. Strong proof is essential, especially in cases of redevelopment or own occupation. When renewal is refused on management grounds, tenants are entitled to statutory compensation based on the property's rateable value, especially if they've occupied for over 14 years. Landlords should plan ahead of lease expiry, ensuring they have the necessary evidence and intentions documented before serving notices. Sometimes, a friendly Section 25 notice proposing renewal is more sensible than a contested opposition. Tenants must monitor lease expiry dates and act early to protect their renewal rights. If faced with an opposing notice, seeking legal advice promptly can help challenge the landlord's evidence effectively. Common pitfalls include serving notices outside the required timeframe, drafting errors, and landlords failing to respond. These mistakes can significantly disadvantage one party, highlighting the need for professional guidance. Imagine a landlord wanting to redevelop a retail unit. If they serve a Section 25 notice opposing renewal without proper evidence, the tenant can contest this in court. Without proof, the tenant may secure a new lease instead. Can a landlord refuse renewal for any reason? No, only on statutory grounds. What if a landlord doesn't reply to a Section 26 request? The tenant automatically secures renewal. Is compensation always payable? Only on management grounds, not if the tenant is at fault. What if the lease is contracted out? Then the tenant has no renewal rights under the Act. Protected lease renewals are vital for tenants and provide landlords with defined rights. They are initiated by Section 25 notices or Section 26 requests. Opposition is only possible on statutory grounds, and courts require strict evidence. Early planning and expert advice are essential for both parties to protect their positions.